Okay, I think we'll start while people are dropping in. So welcome everybody to the SCC Online Seminar series. Today we're going to be talking about how to avoid commercial disputes. And with me today I have James Hope, who is Head of Litigation at Vinge, one of the biggest law firms here in Sweden. So I'm going to give him the opportunity to introduce himself further in just a minute or so. I wanted to start with saying that we are recording this session, so it will most likely wind up in the SCC various digital channels going forward, just so you know. And if you want to ask questions or comment, we highly encourage it. You can use either the chat or the Q&A function, which you can find, I think it's usually on the bottom of the side. So please go ahead and ask any questions or just say hi or comment. And you will also see that when you use the chat function, default is that will only be to us panelists. If you want everybody to see it, you can change who you want to see your message. So before I turn over to James to introduce himself, I am going to say just a few words about who I am. And I am Lise Alm. I'm Head of Business Development at the Stockholm Arbitration Institute. The Arbitration Institute of the Stockholm Chamber of Commerce. My title requires a fold-out business card. I work with essentially trying to figure out how dispute resolution will work in the future and what role the Arbitration Institute should have in creating or being part or not being part of that future. In my previous roles, I'm actually an M&A lawyer. I'm an old colleague of James. I worked at the same law firm a decade or so ago now. And after that, I was at Spotify for 6-7 years. And after that, I went to another startup and moved over and worked more with business development and sales and operations rather than legal. So a lot of what I will be pitching into this session today actually comes from working as an in-house lawyer and the challenges that you have navigating the legal world as an in-house lawyer. So that's briefly about me. And James, welcome and thank you for joining us today.
Thank you very much, Lisa, and very good to meet everybody virtually. I'm sorry we can't see you in person, but we have COVID-19 to deal with, but it does mean that we get a chance to meet people from all over the world, which is obviously very good. And I can tell you a little bit about myself. I've been doing, I suppose, litigation and arbitration for about 25 years. I started off actually in Scotland, and then I was in England, and then I've been in Sweden since 2006. So I have seen things both in the common law side of things and also the civil law side of things, and I've seen a lot of disputes. And hopefully over the years, I've seen how not to do things. We normally see disputes when they've gone wrong. And obviously the very best dispute is the dispute that never happens. And that's what really we're talking about today, trying to find a way to avoid the dispute. And that's the best thing. I was speaking to Lisa before, and she was saying that one of the reasons the Stockholm Chamber of Commerce, the wider Stockholm Chamber of Commerce, is involved in all of this is to try to avoid disputes, because the best thing for us is if people are allowed to get on with their businesses. That's best for society and best for business. So we feel quite strongly about this subject, and we hope that we'll give you some tips today that you can use in your businesses.
And we also encourage you to actually add to the tips as well. I know that we have a number of in-house lawyers with us today, so I'm sure that you have your own tips and tricks on how to do this. So please feel free to contribute. With that, I'm going to jump into today's agenda, and we are going to talk about a little bit about the SCC. I want to share a little bit about who we are for those of you that may not know us so well. And then we're going into the core topic of today, which is why does disputes arise to begin with? And then we're going to essentially walk through the negotiation phase, the the signing, after the signing, kind of the lifespan of the contract, and also what to do if you start feeling that this is starting to mount to dispute. And then if we have time, depending on how this all goes, we're also going to give you a couple of examples of from, I think, especially the wide plethora of things gone wrong that James have seen in his 25 years here. And then, of course, questions, but we'll take questions along the way here as well. We're going to be phrasing this also as kind of 5 tips, so the 5 main tips, and we'll summarize that at the end. And also, we'll be sending out this presentation afterwards if you want to be able to refer back to it. So, a little bit about the SCC. The SCC is, of course, short for Stockholm Chamber of Commerce. And usually when we talk about it, we refer to the part of the SCC that is the Arbitration Institute. We are part of the Stockholm Chamber of Commerce that has an overall, it's a member organization that has the overall goal of increase trade and the opportunities for trade. So we're a non-profit member organization, and that also means, as James were talking about before, our main goal is not to get more disputes to come to us, it's actually to get less of them. So one of the reasons we do this is that we strongly believe that through increased international trade, that creates for a more stable and better world. And I am always a bit hesitant when I use this image because it's such big words that it almost sounds like I am, some sort of sorority girl at a beauty pageant. But we do actually try to work towards world peace. But so for us, the most important would be if you guys never needed to come to us in the first place. A little bit more about the SCC as institution. We are one of the biggest institutions in the world dealing with arbitration. We have about 200 cases a year. They come from 40 or so different countries every year. It ranges a little bit differently, but as you can see from the heat map here, we're all over the Northern Hemisphere. We have a strong tradition with cases that relates to East-West disputes. So dating back of decades, we're talking Cold War type disputes. We also have had a strong connection to China and so forth. So there's a lot of East-West in the type of conflicts that or disputes that come to us. We also deal a lot with energy and with investor-state disputes. What makes SCC stand out, or what is part of the trademarks of SCC rather, is that we are neutral, independent. We're not tied in any way to the Swedish state. We're usually considered to be quite cost and time effective, and we're rather innovative. So that's a rather short snippet about the SCC. And with that, I will go over to the main topic of the day, which is why does disputes arise and what can we do about it? And I'll hand over to James for it.
So we're dealing generally about disputes in business life. And as you know, disputes are, I suppose, inevitable. We are people after all. And I think it's quite a good idea to start there, that disputes happen because of people, and disputes are also resolved because of people. There's always a person or often 2 people who create the dispute and can also try to solve it. With wearing my mediator hat on, we sometimes talk about a triangle where you have one side of the triangle is the people, another side of the triangle is the commercial issues, and the third side of the triangle is the legal issues. And it's important to understand that all those 3 parts are important. If you can resolve the people issues, then maybe you'll resolve the dispute. If you can resolve the commercial issues, then again, maybe you'll solve the dispute. And equally, if you resolve the legal issues, you could. But you have to remember all 3. And that's one of the backdrops that is quite useful to start with. And to remember, of course, that there are often many different ways in which to resolve a dispute. It isn't necessarily always the best thing to do to rush to court or arbitration. There may be another way to resolve it, and it's worth thinking about that in the round, as it were.
So with that, we'll jump into the tips that we have here, and we're going to take it step by step. And these tips that we're going to go through are they're going to sound extremely simple and also quite self-evident, to be honest. But anybody who has worked with as an in-house lawyer or with these kind of questions know that it's a lot harder to do than to say. So the first tip that we're going to say here is quite obvious: write a good contract. There's many things to this, and it's not that simple to do it. But contracts are essentially the same as with relationships. I mean, contracts really are relationships just written down, which means that one of the first steps when it comes to getting a good contract is, of course, who are you getting having a contract with? So choosing your counterparty is obviously a cornerstone of whether or not you're going to wind up in a dispute at the end. Same as choosing a friend or a partner. And both choosing the right counterparty and, of course, acting well towards that counterparty throughout the process. Generally, if you are on an amicable ground with your counterparty, the risks of dispute are obviously a lot less. And when I was working as an in-house lawyer, this was not often something that I could choose. I would just be served with that we're going to be doing this deal, and it is what it is. But quite often you could have a bad feeling about something beforehand. You know already when you start out, you know already when you negotiate, this is not going to end well because of how they act. And if there's any way already at that point to actually say, you know what, maybe this is not worth it, then maybe if there are other alternatives, that might be that's a good start. Make sure that the ones that you get in bed with are the ones you want to be in bed with.
And our next point is, don't be tempted to avoid difficult issues. Quite often, I see situations where we have a dispute because the contract has avoided an issue, normally because it was impossible to agree on that particular issue. And in order to move on, the parties decided, well, we'll sort of park that issue, or we'll simply write something vague. Well, that's fine, but it will come back to bite you later. It's important to understand that. Sometimes it's inevitable, but you do have to understand that that is something that will happen. And then the best thing probably is to try to deal with it in some way, because it may be that if the issue is really difficult, that you actually don't have an agreement. And if you don't have agreement, then you should actually walk away. So facing up to the difficult issues is a fundamental part of writing a good contract.
I gotta say, to underline that, when I was moving from a law firm to in-house, and law firm M&A, I should say, then, where it's very transactional, and you're just in that phase when you sign the contract, you pop the champagne, everybody is happy, and you're going to be sailing off into the sunset. And as a lawyer, as an external lawyer, and I'm sorry now, James, if I'm not just being all positive about law firms, but you kind of walk away at that stage. As an in-house lawyer, you sit with it. And
Exactly.
I realized that, if I write the share purchase agreement, okay, there's a thing or two that will die, but the shareholder agreement, that's going to live for a long time, and it's going to be really hard if you don't have the right counterparty with you to actually amend that afterwards. So that was a steep learning curve for me when I stepped in-house.
Which brings us to the next issue.
It does. It does, exactly. In making a contract that is balanced, it is, especially I found when I was starting out, when you found that really clever way of circumventing something, or either not take the difficult issue or sneak something in a definition somewhere. It kind of came back to the fact that then you're being quite sneaky, and if the counterparty catch you out on it to begin with, it's going to derail the trust of the whole situation, and that's going to live and create much more trouble than whatever you were trying to be sneaky about could ever win for you. And the other thing is, if you even without being sneaky, create a contract because you just simply have so much more power than the other person, they are more desperate than you are, that is not balanced, that they're not happy with, that they feel that they were forced into, they're going to find any which way to get out of it. So again, that base level of trust when it comes to it, and not take every win you can just because you can take it, or you see that possibility for it.
There's also a cultural issue to be discussed there, that in the Western world, now I'm oversimplifying dreadfully, but in the Western world, we tend to think that the principle is the contract should be upheld, pacta sunt servanda. As we go further east, there's more focus on the relationship. And I think what Lise was saying, well, the contract is the relationship, actually. And it's very important to remember that. And so, if you're sneaky in your relationships, normally those relationships don't work out so well. So that's another thing to bear in mind, that's what you're trying to do. You're trying to right the relationship, not to win the contract negotiation.
Same as if you're in your marriage to win, it usually doesn't end so well. If you may get out of washing the dishes that night, but it's gonna come back.
And then that brings us to another issue which we see often as lawyers. Try to write as simply as you can. This isn't a task of trying to show how clever you are or how over clever you are in the way you write. And remember that everyone who uses the contract hopefully should understand it. And in our international world, of course, that means people who have often our international contracts in English. Well, maybe English is their second, third, fourth language. Let's really try to have short sentences, easy words. It maybe doesn't have to be the best language, and certainly not the most formal. In fact, formal tends to overcomplicate. Make it simple and make it clear so that everyone can understand it. And having said that, that's easier said than done. It's quite hard to be simple, but we should all try.
I remember trying to write a contract once where I was trying desperately to define what broke meant. We all agreed that if it breaks within 3 months or whatever, you're paying for it, and if it breaks after 3 months, we're paying for it. But to try and write down what does "if it breaks" mean, it would not surprise me if that's one of the contracts that you saw later on then, James, in a later stage of its life. The other thing is here, and this is from my from in-house, I quite often felt that a contract would come to me, or the BD team, the business development team, or whatever, the sales team or whatever is that initiated the contract. They would come and say, okay, it's all done now. We have a handshake agreement. Can you just write it down? And in my world, they had come from A to B, and I needed to take it from B to Z, because nothing was really finished. And a little bit, as James talked about before, that you didn't necessarily really have an agreement because you couldn't really agree on what broke meant or whatever it might be. And there was also kind of a frustration from the sales team or business development team on how fast is it going or not going, and a lack of understanding on how much is actually left to be done when you start writing the contract. And this keeping them close in that loop to have them fully understand what the deal in the end, from what they think it is to what it actually becomes, is really important, and actually understand what is it that you're trying to achieve, because otherwise you can be really smart with your solutions, but you should aiming for the wrong target. And the other thing that I found was quite often finance need to be involved, and very often because there's money going one way or the other. And very often the sales and business team hadn't really figured this out, or hadn't necessarily done all the checks that they needed to do from that end. So you became kind of just getting it all done in a way that meant that you're not going to have issues down the line, meant safing it up with so many people internally. So you're halfway a negotiator and halfway just a project manager trying to figure out if are we even capable of adhering to these contracts. If I look back to the Spotify time, licensing contracts, being able to actually report and pay in accordance with really complicated licensing terms may actually lead to us defaulting on contracts because we simply didn't have the technology to be able to follow it. So that's obviously one more area.
And then finally here, remember the formalities. We like to think that commercial law is relatively commercial and that the formalities don't get in the way of the substance, but quite often there are formalities, and particularly when we're going between countries, and they can really come back to bite you in a nasty way. And I'm thinking in particular of the situations where you need to be certain that your counterparty actually has the necessary mandate to sign the agreement and to bind the company, or you may need a stamp in some particular countries, or you may need even approval from some authority. All sorts of formalistic issues can creep in. And we get rather technical here that sometimes those are issues not under your governing law, but under another law, under a local law or whatever. So those are quite nasty issues that your lawyer really needs to think about, and which could mean you have to change the scope of the deal or the format of the deal in order to cope with the formalities. So it's something certainly to bear in mind in good time.
I remember we had in one of our subsidiaries in Japan, we needed to have a specific stamp to stamp our contracts for them to be valid, and we needed to have a different stamp if it was bank contracts. We need to have the bank contract stamp. And keeping track of those two stamps were, I mean, that was one of the core things that our first Japanese employees had. Don't ever lose the stamps. We have a question actually here that I think is great for you, James, and it is: how should one handle common law locutions how should you handle common law in English written contract based on if you have a non-common law governing law?
Well, it's difficult to give a sort of simple answer to a question like that, but it's a sort of classic situation where you have potentially two laws that could conflict with each other. And I suppose the real answer is that you should make sure that you have lawyers involved in both laws. But disputes very often arise where you see that parties haven't quite got the advice that they need. I'm thinking of a particular dispute which the SCC had a few years ago, which was an enormous contract that you can't imagine the amount of money involved. But the parties, for whatever reason, decided not to have any lawyers who actually understood the governing law of the contract during the negotiations. It was other lawyers who didn't understand that particular law. That sort of thing happens. And so I think the answer to that is try to deal with the specific issues at the time. But obviously, if you can end up with just one governing law, that's best. Sometimes it's not possible if it's international.
And that kind of brings us, it's a nice segue into the next slide here, which is that we would, of course, you should include then a good dispute resolution clause into the contract. And here it may sound to some extent that I'm talking in my in the interest of the SEC, but one thing that I know that I did at least, and it's not entirely uncommon, is the dispute resolution clause is by definition always at last at the contract. It is sometimes referred to as the midnight clause because nobody cares before midnight, and after midnight the only thing you want to do is go home. And you have a number of things that you need to decide on in that clause, and it's quite easy to use it as a negotiation template. I give you material law, you give me seat, or whatever it might be, or I give you material law and you give me some other formality on whatever it might be. And that's not, I fully understand that. It's quite natural that the main thing that you focus on is what am I buying, when am I getting it, and what am I paying for it. So this does come at the end. But we thought we'd give you a couple of senderways on how to think about for this particular one. And one is, of course, that you're going to be choosing material law. That's one of the things that you usually nail down in this, and otherwise this backup law to help you figure out what it is. But the situation that you described, James, I can well see how that arises because you come to this quite late in the negotiation and you might actually be quite done with the rest of the contract. And then you decide in the eve of signing to flip material law. So you go from a common law to a civil law system or whatever it might be. And you think we're also commercial. It doesn't really matter. Often it doesn't. Sometimes it does. nailing that down slightly earlier makes it possible to assess whether you will actually need to have a local lawyer verify this before you go live. And the other thing that you generally need to make a decision on is whether you want to have court or arbitration. And I will quite briefly just run through what the main traits for arbitration is compared to courts. So one thing with arbitration is that it's internationally enforceable. If you have a court ruling, then it is enforceable in that country. And if you're within the EU, that's generally within the EU, and there's other recognition mechanisms, but generally it's just your own country. Whereas arbitration has, I believe it's 160 something now, countries that have signed the New York Convention, which is the one saying that we should acknowledge each other's awards. So that means that you can actually take your Swedish or your French or whatever it might be arbitration award, and you can enforce it in China or US or wherever the assets of your counterparty sits. The other thing is that it's confidential. So it's not public, which is often a strong argument for commercial disputes. The arbitrators are experts, so they are appointed by case for case. So the institution or whoever it is picking the arbitrators will choose arbitrators that are experts in the field of that specific dispute. You don't have any appeal, and there are time limits on how long you can do this. Or how long the process can take. So it's a lot faster than going to court. You also don't have any appeal. There's obviously that's a dual-edged sword. If you don't get the award that you want, that's the end of the line. When it comes to this, there is a very simple solution. When you're sitting there midnight, go into the arbitration institute of your choice, us or the ICC or LCA, which is London and so forth. There's a number of good ones. And just copy and paste the clause from their website. That's the easiest way to get it right. Don't engineer this one or think, just copy and paste. Unless you want to have court, of course, then you're on your own.
And the easiest way to get it wrong is to try to fiddle with the clause and think that you can do better than the institution. And I think we've all seen, those of us who work in arbitration, we've all seen attempts to do that have gone wrong.
Yes, and when we sit in them, we have the board meetings at the SCC when we appoint the arbitrators, and we try to interpret these clauses that people have been writing themselves. And it's a number of really, really senior arbitrators around the world. James is one of our former board members and so forth, looking at this clause. And I think it might have been you once, James, that said, so let's try and figure out what the parties were trying to say. And sitting there as a former in-house lawyer, I'm thinking they were just trying to get home. They weren't trying to say anything. They were just, picking words randomly out of a hat. That sounded like something that to do with dispute clauses. We get a lot of engineered clauses. So make it here. The fastest and easiest way is actually the best way. Just copy paste.
I can't resist telling a story that I think in the SCC board, I think we once got a clause which it was one of these arbitrations, one of these contracts, which was joint English language, joint Russian language. And the Russian language provided for the ICC, the International Chamber of Commerce arbitration, and the English language provided for the SCC. And that didn't really work, did it? So
That's not great.
No.
We're actually going to be talking about this specific clause at more length in a session next week, where we go through the different parts of it. What do they mean? How do you go about if you want to negotiate it? What are the things to think about? If you want to have fallback options, what should you think about when you do that? That will be a 45-minute version of what we just said, but with more words. We're going to finish that one as well with saying you could skip all this and just copy and paste, but since life doesn't always present itself that simply, that the counterparties accept that as well, then we want to give you some flesh and bone. Flesh to the bones. So feel free to sign up to that one. You'll find it at the same place as you signed up for this one. We have one more question, which is about mediation, and we're actually going to get to that when we talk about when you start getting close to a dispute. One thing to mention is when you choose court or arbitration, one of the differences there is that they are mutually exclusive. So if you choose court, you can't go to arbitration unless you agree to change that. If you choose arbitration, the court won't take you unless you agree to change that clause. Mediation, you can always go to regardless. So that's why it's not necessarily, I mean, it's definitely an alternative to this, but they're not exclusive in the choices as court and arbitration is. Okay, so next thing is, after you've written your great contract, is to keep track of it. And
so I think if I can take over, you now have your contract, you've written it, and hopefully you're getting on with your business and your friends with your counterparty and all of that. But you should keep a note of what you've agreed. Not only should you make sure that you have the contract to hand, quite often you see that parties basically put the contract in a drawer and ignore it, and it only comes out again when there's a dispute. And the only people who actually know what it says are the lawyers. That's a bad thing to do, because it's obviously much better to follow what the contract says. It makes it easier when an issue arises. I think it's also good to have your own note of what the business deal is, because that's also vital evidence if things go wrong. So it may be that, in fact, what you did is that you agreed as business people, and then the lawyers turned that into a contract. But nevertheless, keep the note of the business deal somewhere as well, because you may well need that later. Then, of course, you need to be careful about what you've written down, because some of this information could be disclosable if there's a dispute. And both that's things that you've written down during the contract negotiation, but also things you write down afterwards. And when I say written down, I mean in anything that is writing in some sort. The really difficult thing is people who write text messages. Text messages are also discoverable or subject to requests for production of documents. And people write things that they think will never be seen by anybody else, but that's not true, I'm afraid. Even if it's an internal little message to your friend down the road about how terrible this contract is, or to your business partner or whatever, if it's written down, it can be disclosed. So the watchword there is, if there's anything really sensitive, either during the negotiations or afterwards, don't actually write it anywhere. And don't say it in a telephone call that can also be recorded. If you actually want to say something confidential and sensitive, go and speak to somebody face to face. And if you're really worried, sometimes people are worried about things being bugged, go to the forest or something like that, so that actually no one can hear you. It is actually really important at that point, particularly as the world becomes more and more electronic and everybody can record everything everyone says.
Should have like that room, I think it's in Edinburgh Supreme Court. There's this glorious room where people can walk up and down the room. Yes. Because it can't be overheard. Because it would be, you would see if somebody's hearing you, and if you bug it, you will only be hearing the snippets that when you're in the right end of that room.
It's actually quite a good trick that you should, if you're walking along, then people can't hear you unless they actually walk with you, and then it's very obvious what they're doing.
Exactly.
So walking and talking is quite a good way of disclosing sensitive information.
The other thing, it kind of alludes to what you were saying here, is and make sure that you understand the contract. And this seems like an obvious one if you just negotiated it, but at least I must admit that wasn't necessarily always the case. If you've negotiated a bank contract or something else, that is just so much detail to take in. So, and especially when you have outsourced this to external lawyers. And they've helped you and they've understood the whole thing, and you feel quite confident that this is a good deal, but you haven't really understood it. And this ties back a little bit to the first point there of writing down what your understanding of the deal is, which may be simpler than having a 200-page bank deal that is really tricky for you to follow. So to having that overview. And the other thing that is even harder is make sure everybody else understands it, because you may have negotiated a really good solution and you're all agreed with it with your counterparties, but the main thing here is quite often it's not the lawyers that creates the issues that becomes a dispute down the line. And I mean, you all know this, but it's obviously somebody else down the line not necessarily wanting to create issues, but didn't really understand or know what was the issue. So making sure that everybody else and all the other teams understand the contract is really important. What was the actual deal? And also so that they know when to come to you if they want to amend it, or if they have done something strange, or if they're sensing that something is going on the other side. And the other one is keep track of the contracts. So for this, to another story on when sitting at an M&A side and we were doing a data room and we're getting all the contracts of a company, and it was called they kept referring to it as the coffee box, and I never really understood until the coffee box was delivered to the law firm. And it was an actual coffee box. It used to contain coffee grains. And now it was the box that was standing next to the printer, so that when the documents came out of the printer, they would just simply fall down into the coffee box. And that was their filing system, together with, printouts of receipts or whatever it might be. So just trying to figure out what was actual contracts in this and how they stuck together was about 2 weeks work. That wasn't great. So there are various systems there. Another one is to keep track of the people. And by that, I meant who is authorized to sign and act on behalf of you. And this is, these people can change the contract through their behavior. I'm looking for the English word for konkludent handlande, James.
You can make contracts by your behavior.
Okay, so there's no one simple good English word.
No, exactly.
Darn it. Okay,
but that's what you're referring to, I think.
That is what I'm referring to. But if you're clear with both internally but also externally who actually has the power to tie the company, that is a key point in not making a mess here. And the last thing is keeping track of your inboxes. And I put this one here also to just be able to do another brief story on. We set up an office in Germany, and we had some salespeople there, and salespeople are great at sales. They're not necessarily always the people that you trust with your original documents. So they're all over the place, and they're flying. Then almost never at the office. But so it turned out that we had a request from the German data authorities laying in our inbox or in our mailbox actually for 6 weeks or something before it was found. That's not great. So just being able to know, okay, am I on top of all the channels I could get sued in? It was quite an expensive one to not realize that, hey, when we set up an office here, we need to have a mailbox check. All right. Moving on to the next one here, that is once you have your contract, you're keeping track of it, then you need to stick to it.
So you need to follow your contract, quite simply. And again, that sounds completely obvious, but in the real world, you're not doing that. You're just doing your business. You're going out selling, you're doing whatever it is, and you're assuming that everything is working. But if something goes wrong, then everyone will jump to look at what the contract says. And if the contract if you've departed from what the contract says, then you're going to have a problem, either because you've created some new contract by conduct, which is in itself a problem because there's all sorts of problems of proof there, or because what you've been doing for the last 6 months or whatever it is actually a breach of the contract, and then you're going to have a problem with that. So it's as well really to try to make sure that you're sticking to what the contract says. And the next point, of course, is that the world changes. things change. That's in the nature of business. And when they change, now, again, this is an ideal world. In an ideal world, you say, oh, look, it's changed. We should regulate our new relationship in some way and write it down. Now, in practice, of course, things don't normally happen that way, but you can try, you can at least have an attempt, or you can have some sort of exchange of emails where you agree what you're going to do next. But if you simply leave it, then it's a problem. So that's something to bear in mind. And then, as we've put, sometimes the world changes a lot. And of course, the classic example is, I'm afraid, COVID-19. We might have a force majeure situation. We might have a situation where, in fact, you cannot supply what you said you'd supply, or where the price goes up by some ridiculous amount of money, or whatever it is. In those situations, I think the only thing to say is you have to contact your lawyer. But you may be in a situation where, in fact, it was simply so unforeseen that you're in some sort of hardship situation. And in those situations, different laws deal with it in a different way. You might have an ability to get out of the contract altogether, or you might have an ability to vary the contract, or whatever it might be. But that's clearly a problematic situation where warning bells start to ring, and you have to contact your lawyer.
And again, I'm a bit curious here, James. Have you seen a lot of force majeures based on COVID-19?
The answer is that all of that is bubbling away. There are a number of situations which are working their way through. Disputes tend to be a bit delayed in time, in the sense that it takes a few months for the dispute to end up in a court situation. What we have seen, and I'm sure a lot of people on this call have seen that there was a big case actually in the English courts about insurance and COVID-19, which they fast-tracked to get a decision, which was very impressive actually. But more generally, on the force majeure side of things, there are quite a lot of issues. I think a lot of us have seen those sorts of issues. They're bubbling away. I suspect we will see those things coming to court in a major way over the next year or two. Yeah. Although one would hope that they can be resolved. And the watchword here is to try to deal with it quickly. Yeah. If you wait and hope for the best, if you act like an ostrich and put your head in the sand, that's never going to be good. But if you deal with it up front and say, look, everybody, this is force majeure, we're going to invoke the force majeure clause, we're going to talk about it, we're going to try to resolve it, we're going to act commercially, that's the best way to deal with it. But it's not easy.
Now, force majeure seems to be, to me, when I was reading it before, it was generally something that felt like, well, it's an act of God and so forth. COVID-19 has really made those things seem very real all of a sudden.
Exactly. And one of the difficulties is it sort of depends on the situation, who's in the force majeure situations. Some people will be unable to deliver the goods they said they deliver. I had a force majeure question last week from somebody who was supposed to be providing people to a project, a power station in Russia, but the border was closed because of COVID-19, so they can't get there. So it sort of affects you in unforeseen ways, which is in itself a problem.
We actually have a question on force majeure. Insurance clauses are numerous clauses. However, force majeure is sui generis, I believe.
Well, I think this is a very, very interesting question, and this was in fact the focus of this case in the English courts. I'm sorry, I can't remember the name of it, but if you Google English courts insurance case COVID-19, you probably will find it. And the issue there was whether, in various different sorts of insurance situations, COVID-19 was covered or not, and obviously, the insurers, or quite a lot of insurers, were saying, no, you're not covered. And a lot of the insureds were saying that they were covered. The English court found, on the basis of certain specific wording, that COVID-19 was covered, and therefore that there was insurance for the COVID-19 situations that were the subject of that case. Whether that applies to other laws remains to be seen. And I think this is a very live issue at the moment.
All right, so the next thing, when you start kind of getting to a potential dispute, the first thing here, of course, is knowing knowing when to fight. And one thing to just keep in mind on here is of course knowing the signs of, are your counterparty actually gearing up for a fight? And this might be, you might understand the signs, but this is also of course something that your business people need to know, or the other, whoever is the one who is actually having the day-to-day relations with your counterparty. And there's some various tells if their language in their email starts going from quite your everyday back and forth to something that sounds a bit more lawyered, and you understand that there might be a lawyer behind here, or making references, and I'm sure you have even more examples, but making various references back to what the contract said, or if you stop taking the calls because you want to have it all in writing, and you notice that you can't get a hold of them, and it takes an extra 3 days whenever they answer, and it's lawyered and so forth. When you start seeing that as a lawyer, you kind of know that, oof, we're okay. As a business person, you might not pick up on those tales, and you might run into something that you keep answering while you actually might need to start lawyering up yourself, or at least start thinking around, what am I looking at here? And I don't know if there's any other big tales here that you're thinking of, James. But
one of the things I'm particularly thinking about is this issue that you have to be careful what you write in emails. The moment you think your counterpart is likely to be gearing up for a fight, stop writing any internal emails that you would be embarrassed about if they end up in court.
Yes, and that point about internal is obviously well made, because that's important. The other thing is also, of course, check the contract. The first thing there is check the contract. There might be just a simple solution to whatever it is that is bothering either party. But here, and this ties a little bit back to mediation, for instance, can this be solved amicably? Either through that there are mechanisms in the contract, we've just forgotten about it, or that you have negotiation or mediation, I see median here, but mediation between the senior management, and mediation, you can have formal setup mediation, or you can just have have your external lawyers help figure this out in a good way. There might be various commercial solutions, obviously. One way of just throwing money at the problem, or maybe buying a part of the company, or maybe whatever it might be that shortcuts whatever the issue is. And then not too seldom there's people issues here in the background, which essentially, I mean, it could be as basic as is there somebody who has been offended somehow? Is there any emotions tied to this that can actually be handled through that way instead? Or are there any specific people on either your side or their side that is a block to finding an amicable solution? And if there is there a way to maybe remove them from the situation, escalate this, or create a different setting for the negotiations to take place, so that you have a bigger chance of resolving this amicably?
And one of the things you see sometimes as a lawyer, an external lawyer, is your client will come to you and say, we've got a point of principle, we want to litigate because we want to show the other side that they're wrong. And if you step back a little bit, you can very often think, well, actually, that might be good for you because you'll feel better, but it may not be the best commercial solution. And yes, it's a question of thinking about picking your fights. It may be that you do want to show the other person that they were stupid, but actually that's not the best thing for your business.
Yeah.
And that requires hard thinking and maybe changing the team looking at it and all of that stuff. But it's worthwhile just stepping back and thinking before you rush in.
And that kind of brings to another thing, because I think you may have emotional aspects that we just described here. One of the potential emotional aspects that lawyers sometimes have is, I have such a strong case, I want to pursue this. Or I actually did think about this situation in the contract, so I have put in the contract, and now they're not doing what they want to do, and I'm pissed off. So to actually assess, okay, how strong is your case, is obviously a natural starting point to see here. And the other thing there is, the other side to that is, how important is your case? Is this one of those principal cases where you really need to have this nailed down, because this wording or whatever it might be, we have it in 10 other really important contracts as well, so we need to figure it out. But the other one is to look at this as you would any other investment in the company. And
just before we do
sorry,
that,
yes,
this point about how strong is your case is also about, are you going to be able to prove your case?
Oh yeah.
In other words, do you have the evidence to back up your case? And also, do you have are you prepared to go through with it? Which maybe comes down to this next point. But it's one thing to say, well, in theory, I have a strong case. But if nobody in the company is prepared to put time and money to having a court case, then actually you don't have a strong case because you're not prepared to go through with it.
And is that key person that holds the smoking gun, is he or she still actually at the company, or do you have you saved up everything? And I know you're going to be talking a little bit about that. And I realize, just as you were, I thought, James, that we were going to have a lot to say in less time than we want. Look at this as you would any other investment. You're going to be spending time, money, and a lot of gray hair on this dispute. Are you gonna, what's a realistic amount of money you're going to be spending on this? What is the realistic risk involved in this, and what is the time you're going to be spending? And if you were to come with any other investment that you want to make, then you would need to present usually some sort of return on investment calculation. And I think that makes a lot of sense to do for disputes as well. And I know some companies do, and some companies view it from a different angle. A key aspect here when it comes to the risks is, of course, even if you do go through with it, you spend all the money, you show your case, you prove your case, you win the case, and then you need to enforce it. Do they have the money? Do they have the money within reach? What will it cost for you to actually enforce your award? So that is also something that you need to bear in mind. And of course, the third thing here is, if you didn't spend all your time, money, and gray hair on this, what could you be doing instead? And what is the better investment for your company? So those, just seeing it as a business transaction, it's one good angle to assess this.
And we're slightly running out of time, but I think this is our final sort of main point, and this is how to fight. And again, we've talked about not writing down things that could be a problem, but there are some other fundamental things you need to think about. The next bullet is give notice of your claim in time. If you don't do that, you could lose the right to bring your claim. And some laws are stricter than others. Swedish law, for instance, is really quite strict about this. And you don't want to make that sort of fundamental mistake that ends up meaning that you just lose your claim. Evidence, of course, is very often key. And if you haven't assembled your evidence, or you don't have the contracts to hand, or key point, if your key witnesses have just vanished because for whatever reason, well, then you're going to have a problem, and you need to face up to that quite soon. There's no point in saying, well, we would have had a good case if the person had still been there. If he's not there and you don't have the key witness, well, you're not going to be able to prove your case. And I suppose, finally, never ever underestimate your opponent, and don't assume the case will settle. Quite often people will say, well, look, we'll sue them and then we'll see if we have a good case, and one way or another we'll reach an agreement. Well, the moment you sue, then people dig in their heels and say, right, we're not going to settle, particularly if the other side actually has a good case. And then you may end up really regretting the fact that you sued. You always have to think of the end game. What is your end game? And your end game is to win. And in order to win, you have to have the ammunition. So that's a key point.
And that's really, the whole, if your end game is to win, that kind of brings us back to the beginning. Once you've come to a point when it's I win and they lose, then you've lost that entire base for being able to move on and have an amicable resolution after this, because you really need to think about where do I want to end up with this guy? Do I just want to win and then we can never meet again? And the last point on this one.
Yeah, the last point is that, as I think we've said already, you need to have the money and the people to take the fight all the way. And sometimes that's different people in the organization. You have to be sure that the organization is behind this, because a case, as many of you know, but some maybe don't quite realize, takes a long time. I'm afraid even the simplest of arbitrations can take about 3 months, more likely 6 months. Big cases can take 2 or 3 years or even more. And that's a long time in the life of a company. So you really have to be sure that you have the intention to go through with it.
And that's just from when they come to us. I mean, obviously,
Yes, exactly.
you've been rattling your guns for a while before you even sue.
Mm.
So to kind of sum up what we've said over the last hour, the really simple and still really hard thing to do to avoid contract is disputes is write good contracts, keep track of them, stick to them, know when to fight, and know how to fight. And this is a lot harder in practice than in theory, but it should take you some way. Before we wrap up today, I have one more question, unless there's anybody else who wants to ask a question, but we have one more question about that insurance case, and it is whether it's not still pending in the Supreme Court.
I think it may be. I think that's quite possible. I know that there was a fairly definitive ruling, but I believe it. I don't know for sure. I think it could have been appealed. And certainly this is a big issue that will continue to be an issue. And obviously it also depends on the specific circumstances of the insurance product that you're dealing with. So it will continue to be an issue to discuss. And hopefully in the end, we will have some sort of resolution on it. I should say we have a number of examples that we've given. They're all real life examples of cases that I've been involved in or that Lisa's been involved in, which show what can happen when things go wrong. I don't know if we've got any more time, actually, do we?
I think we have about 2 minutes left.
So
pick your favorite. They will be part of the presentation that we will send out, however, but pick your favorite and see what we've got here.
Well, one of them is, I suppose, the third bullet point here about the bank enters into a contract with an IT contractor, and then there's a dispute, and then you look at the contract and you find out that the contract is enormous. I mean, 100 pages long and almost impossible to understand. And then you realize that actually you're not very sure what the IT contractor what their responsibilities are. And that's actually quite a classic situation. Very often we have these very, very long contracts and it's difficult to know what they really mean. People put them in a drawer. And then when it turns out that you have a dispute, it's quite difficult to pin down what you can use the contract for, because it's been worded in a way that isn't so easy. So that's a situation that we often see. I also want to touch this on.
Then say one thing that I often saw at Spotify is we have somebody with a counterpart or someone with some relationship. You realize there probably need to be a contract here, and they say, "Oh no, don't worry, we do have a contract with them already." And when you find the contract, more than half the times it turned out that we had an NDA with them, and that's it. But we had a contract, so obviously we're covered for whatever it may need.
Yeah. And then I think possibly finally, we're on the next slide. We have an example. If we can go to the next slide.
Oh yes, sorry.
We have an example about this Danish company with a US distributor, but then the contract comes to an end and they just continue. Well, that's a classic situation that happens in many businesses. You don't really think about the situation, you just continue. But then if there's a dispute, it's very uncertain what you really have. What is your new agreement? Is there a new agreement? Is it the old agreement you're continuing to contract under? All those sorts of issues are problematic.
And this brings back the need for something other than a coffee box for your contracts. There's quite a lot of systems that will help you automatically keep track of termination dates, notice dates, and so forth. That makes you avoid these kind of things.
But I suppose that the final thing to say is, if you've got a good relationship, you won't have a dispute. It's a bit like people don't sue doctors that they like.
Yeah.
So remember always to work on the relationship. I think that's possibly the key message, the key takeaway.
Okay, I think with those words, we will wrap up for today. And thanks a lot, James, for helping us shine some light on this simple but really, really hard questions. And thank you everyone for joining us today. As I mentioned, we will be sending out the presentation for you in a short while here, and potentially put this up on the website going forward.
Thank you very much. Very good to meet you all.